Thank you very much, Dr. Abdul. That's such an insightful one. We have a few questions. I will ask a few questions before I will move on to the members on the gallery. Your presentation is quite good, and I'm happy I've learned a lot. But before that, I just want to do a few recap. You are saying that it's mandatory for companies to register with your agency, that is the Data Protection Commission. You talked about a person who processes data, and a person who processes data, is required. So you mentioned data controller, you mentioned data protection supervisor, and you talked about a data subject, which is we, the employees of the company or persons whose personal data is being processed by the agency. You talked about the fact that appropriate safeguards should be put in place by the data controller to ensure that the personal data is properly protected so that it is not breached, so that there's no breach of privacy, whether at the personal level. You talked about the principles, and you talked about the fact that consent can be withdrawn by the data subject. And I think that's a very insightful. So I have a few questions asked, then we will proceed on to the members of the gallery. So from your point of view, when you talk about personal data, what do you mean? What is a personal data? What constitutes personal data from your point of view?
All right, thank you very much. So from the, I believe by saying from my point of view, you mean to say, or you mean to ask?
Asking from the law, yes. I mean,
yes.
How does the data protection see what is personal data?
So the data protection sees personal data as the data, that relates to a living individual. So the data that relates to a living individual, a person, a person that's, the person that's alive, living. So from the laws, from the Data Protection Act's perspective, personal data is the personal information about a living person or a living entity.
So can we talk about the race of the person, the color, the tribe, the religious belief, the medical conditions, the sexual orientation, issues about age and all that? Those would still qualify as a personal data. Is my understanding correct?
By far, they qualify as personal data. However, there are some particular forms of data that the law considers as sensitive data. And this kind of data must be processed by clear consent or by law. So name, age, I mean the emphasis of what we consider as personal data. The explanation I give, the emphasis is that it must be for a living person or a living individual. That is the emphasis. However, to answer this question, I'm saying that all the things you mentioned, the sex, sexual orientation, age, race, and all that, they are essentially people's personal data. However, some of them are classified as sensitive data. And so in processing those sensitive data, like sexual orientation and religion, these are personal data, all right. But some of them, like I said, which are classified as sensitive data, in processing them, there must be very, very strict consent and intent.
Okay. You would agree with me that within our legal construct, where we find ourselves, some of this information are not really well protected. I mean, in the UK, for example, your age is your date of birth is very important. But you would find that where we find ourselves here is not something that people really cherish a lot. So I'm happy we're having this discussion. You talked about the controller. So in the context of a company, who qualify as a controller, data controller, because obviously the company is a data processor. So who should be appointed as a data controller? And who should be appointed as a data protection supervisor in the context of a company? Let's take a company which is a manufacturing company. I mean, who qualifies as a data processor? The company obviously qualifies as a data processor, but in terms of who should be a data controller data protection supervisor.
All right. So the company itself is the data controller. And from the commission's perspective, the decision maker, the key decision maker is a person to call on when there is any data breach. Now, the data controller, it becomes even if it's a manufacturing company, the company becomes the data controller. Why? Because, I mean, manufacturing companies may not necessarily be taking so many other data per se, but at least they have employees. And once they have employees, they take the personal data of those employees. And who is taking those employees is the company. So the company becomes the controller. Now, you also asked who then becomes the data processor. If for any reason, the company has to source out the processing of this particular data they have collected from their employees to another entity or another company to process this particular data, that second entity or that second company becomes the data processor.
I agree with you, but the point is, a company is an artificial construct. It cannot process data as you put in it. These are done by individuals in the companies. So that's what I'm asking exactly, because, for example, if you take an HR person, they have all our personal information. And your law says you have to designate someone as a data controller. So, I mean, even per your own requirement for registration, you expect to earmark someone as a data controller, whom you holding accountable, but not the company as an artificial construct.
Okay, yeah, so I think I'm understanding what you mean. Now, our law doesn't say that somebody, I mean, the company should designate somebody to become a data controller. Rather, the company must appoint a data protection supervisor. A data protection supervisor. Now, the person now becomes responsible for, you know, the privacy, the policies that concerns privacy and all that about and for the company. So the data controller is the entity, but the entity now appoints somebody called the data protection supervisor, who now it's like a company that has an accountant. Essentially, the company, the money is going to the company, the money is for the company, the company accounts for the money and all that. But the work, the detailed work in there for the accounting and then the writing and the balances and all these things is that work has been given to the accountant to do. So in the same case, there is the company being a controller. And then in there is a data protection supervisor. And that is what the Data Protection Commission trains. We have certified, I've seen one of our trainers around, that is IGS. It's good to mention them. They are doing a great job. So we have certified some of the, some accredited institutions that are responsible for running trainings for data protection supervisors from individual companies. Now, the data protection supervisor becomes responsible for all this architecture of data protection within the institution.
Thank you very much for the clarification. If a data controller, a potential data controller, wants to register with your commission, what are the requirements? What is expected from the potential data controller to enable the person register with your agency?
All right, thank you. Let me say that, you know, yeah, I mean, this is a very good question, but I want to rephrase it. Now, it should not be that if a company wants to register with our commission, no, it should not be like that. It is not an if, it is a when. Because every single entity, every single data controller must register with the Data Protection Commission. And many of the times, my good friend, many of the times, when I say it or when I put it, my intent is not, it's not even about the commission, but it is about because you see, whether we like it or not, when our personal data are not properly protected, it will affect everybody. Theo, as you said very beautifully as a lawyer, and you are doing your job. If care is not taken, and somebody doesn't, you give your personal data somewhere, and the person does not do the right thing simply because they have not even bothered to understand what data protection is, you are affected as well, and every other person on this list. So the law mandates that every single data controller, every single entity that takes or works with any form of personal data must register with the Data Protection Commission. And if you want to find that out, that is in the section 91 of our act, and it's a must. Now, how is it done? The Data Protection Commission is endeavoring, and I think we are doing our best to make the system of registration very easy and simple. So a person doesn't have to walk all the way and come to our office. You just go to our website and register. The registration is very digital. Our executive director is very bent on running a very digital system. So you go to www.dataprotection.org.gh, and then you will see a red blinking register indication, like that. You click on it, and the system, an interface will roll out that will allow you to register. It's a very, very, very simple process to register. You key in your information, and then we add that you add your, we submit that you add your some other backing document, and then the commission will pick it from here and process it for you, and then you receive your certificate. So go to www.dataprotection.org.gh and click on register, and you'll be given an interface that will help you to finish this.
Thank you. So we have to add our registration documents to the application process, correct? Yes,
there are some documents that you need to add or support the registration with. And there is a reason. Now, the reason is that there was an amnesty that was launched from October 2020 up until the end of March 2021. What is the amnesty? The amnesty stated that any institution, that had not been in good standing with the commission from the setup and the work, the setup of the commission, the section 97 of our act states that. Let me read that out for you. This is 97 saying that. Subsection 1 says a data controller incorporated or established after the commencement of this act. The act came in 2012. So a data controller that is incorporated or established after the commencement, after 2012 of this act, shall be required to register as a data controller within 20 days of its commencement of business. So if you are registered after, let me ask, Phil, are you registered? Is Nobby Field registered?
Yes, we are registered as, and we have actually recommended all our clients to register. So Hilda would affirm that we are happy about that. It's a key requirement for us as a firm as well.
Great, that's a good practice. We hope that everybody here will do it. Now, so you register, and now because of the amnesty, there is a way we have to substantiate everybody's registration. So we request of you to upload your certificate of incorporation, because of these acts. And then if there is a need for any arrest, we run for you and all that, we'll do it for you. So it's a very simple process.
So my further question relates to, we're in COVID time, and you go to a number of businesses, they're taking your ID, your temperature, they're taking your personal information, your name, your telephone number, where you're coming from, your temperature and all that, whether you have fever or stuff like that. How do you ensure that those who have not registered with you are not taking this mandatory requirement?
Yeah, you're right. So there are, many institutions, especially in the breakout of the pandemic, institutions. Oh, let me just say that everybody was doing it. Every single institution was doing it. How do we make sure that, the question is that, how do we make sure that,
because if you're processing the data and you are not registered, that's really in breach of statute.
Sure. So the question is, how are we making sure that?
Yes, that people are registered, and so that we are also protected as a data subject.
Okay, great. So what the Data Protection Commission is doing to make sure that people who are not registered and people who are not allowed to take people's personal data don't take it. It's on different levels. There are different levels. Again, let's note that. And I want to quickly accept the fact that there are some non-compliant data controllers who are taking personal data. I want to admit that. But then again, come to you and say that there are various levels of activities we are doing to make sure that these things are minimized or eradicated. One is that we are collaborating with other regulatory bodies to make for institutions to add data protection as an eligibility criteria. For instance, if you go to Bank of Ghana, there is no bank in this nation that will be allowed to operate without a data protection certificate. So if you are into banking or fintech or all that, you need a data protection certificate before you can register, or before you can get the mandate to operate in this country. Now, we are doing same with many, we've had an MOU with the Internal Audit Agency to run such systems and many other regulatory bodies, so that we regulate, because you see, Theo, the Data Protection Commission, it will be too much. It will be like chasing after the wind to go after, to try to go and search for anybody who is trying to pick somebody's temperature without registering. So we are working collaboratively with, regulatory bodies. And then Data Protection Commission or Data Protection Certificate becomes part of the eligibility criteria for these people or for this institution. That is one. Two, we are embarking on enforcement activities. On the 29th of July, 2021, we launched or we published the list of entities that are in good standing with the Data Protection Commission. And we've informed the public not to do business with any entity that has not done the right thing with data protection.
Okay, that's go ahead.
And this is to inform the public. This is to inform the public that if somebody does not appear on that list, be careful. Don't give your personal data to them. We are not only ending it there. By the good work of the executive director, we are compiling the list of institutions that we have served letters to come and do the right thing, and they've not done it. We are compiling the list for prosecution. We've compiled the list of prosecution, and we will do it.
That's a good point.
So it's a stream of work we are doing, from collaborate and again, like these trainings that we are sharing to keep educating. The best that we could do is to educate the Ghanaians to know that if anybody has not gotten a data protection certificate, don't deal with them. That is one of way to push all data control, because of course, because of the customers and the clients, they are there. And if the client insists on the protection of their personal data and insist on the registration of any institution to have a data protection certificate before they do business with them, the controllers will come. So this is a multi-level tier of engagement. We are, like I've told you, all these things we are doing, and we are wanting the entirety of this country to rise up to the fact that data is the new goal and it must be protected.
Thank you very much. I'm aware the Bank of Ghana has it as a requirement for the fintech company. So we hope that others would also follow suit. But are there any exemptions for certain companies who are not subjected to your law or registration?
Yes, thank you very much. Yes, of course, we know that to every law, there are some exemptions. So our act makes for the exemption of certain institutions and certain entities. Many of the times, they are entities that must process data for national security reasons, entities that must process data in national emergencies, entities that must process data, for the general good of the entire country. So yes, the Act has made set provisions for such institutions.
Okay, so just to add up, national security is one, tax issues involving crime and tax, health, educational institutions, social work also exempted. Regulatory activities, institutions subjected to regulatory activities are also exempted. Journalists are given some exclusions. If you are expected to make a disclosure by law, you are not expected to comply with the data protection. In the domestic context, you also given exemption. Armed forces are also given some exemption. So not everyone is expected to comply in that respect. So apart from those exceptions, everyone is expected to register the data protection, because by virtue of whatever you do, you process data and you'll be a data controller.
Yeah, let me help a bit. I mean, the exception doesn't mean they shouldn't comply with the data protection law. Or it doesn't mean that they shouldn't protect people's personal data that deals with them. The exception only means that there is a leverage for them. They can process personal data in times of emergencies and all these things, and the commission will not rush on them. It doesn't mean, what I'm trying to say, that doesn't mean that it can just go out there.
Understand that. But if you look at our ecosystem, most businesses are SMEs, and the fees that you're charging, my senior lawyer, Francisco Boateng, think that the fees is on the high side. And we have to consider reducing the fee, the registration fee for the data controller and the data processor. I had my colleague, Richard, register with your institution last month, and he paid 8,000 cedis to train as a data supervisor. I think it's on the high side.
Right. Thank you.
About it.
Sure. Let me tease out the question well, so that the answer comes out well. Registering is different from training a person as a data processing supervisor. And so when you are coming from a place of saying that, of course, in our ecosystem, we have a lot of SMEs, and the fee for registering is high, I want to bring clarity to that. And let me start from the premise that the fees that the Data Protection Commission charges, they are cleared parliamentary fees and charges. It is not the board, neither is it the commission, the management staff or the commission that has stipulated these fees and charges. It is the parliament that has given those fees.
No, we understand that. Yes,
now, quite apart from that, with registration, the commission, the practice of the commission gives room for 3 different categories of data controllers. We call the first one, small scale data controllers. And Theo, for 2 years, the small scale data controller must register their company with the commission with just 120 Ghana cedis for 2 years. I mean, how on earth can this be? So
how come you charge me about 800 or something? I can't remember.
And so like I'm saying, we must tease out the registration is different from the training of a CDPS, and I'll explain the training of a CDPS. So a small scale data controller must pay 120 Ghana cedis for 2 years. Look, we must be honest with ourselves. This is good. 2, a medium scale, which I know that we have a lot of them. A medium scale data controller must pay 900 Ghana cedis for 2 years. And a large scale, look at VRA and Bank of Ghana and all these huge banks, they must just pay 1,800 for 2 years. They are large scale data controllers. So that is for registration. And you and I will accept that. This is fair enough. Now, when you have to deal with training of the CDPS, that is what you talk about. That is what costs 8,000. So let me put it on clear on record.
I understand that. I'm happy you admitted most companies sit with a medium level. And I mean, 800, 900 cedis is quite on the high side. So what we are urging is that when you have an engagement with Parliament next time, we have to consider, because I mean, businesses don't just register with your agency alone; they have other obligations. And when you put up all together, the overall cost is high because you're just registering.
I perfectly understand. I think that is something to pick up, but I think it's also very good to use this platform to encourage our listeners that look, for 2 years. Theo, I don't know if you consider your institution, your law firm, as a medium scale or large scale.
I think we are medium. I mean, I feel like 900 or something. Yeah.
Can you imagine? Look at this big institution of yours. When you were saying, you say you have a big mother company, UK, so many countries, and this huge institution, we are saying pay 900 Ghana cedis for 2 years.
We are fighting for the commoners, everyone.
All right, it's understandable. It's something to pick up. Yeah. Now let me explain the 8,000 you talked about, so that nobody picks it up in a wrong way. The 8,000 is the fee that is charged for a CDPS. What is the meaning of a CDPS? CDPS means Certified Data Protection Supervisor. Now, this is the Certified Data Protection Supervisor is a person who has been trained and is to be certified by the Data Protection Commission as a person who can render data protection as a service. This is so important that we understand. Look, as data protection becomes known and as institutions and entities start, the need for data protection supervisors to rise, data protection supervisors is becoming a hotcake. And so we are saying that you can offer data protection. I mean, every single entity in this country, sooner than later, will need a data protection supervisor. And just like you would have needed an accountant, somebody would have had to go to school, and you can imagine the amount of money they would have paid to become a certified accountant. Now you are becoming a certified data protection supervisor. You could even use that certificate after you've practiced for a while and you've been certified. You can use that certificate to run a business of your own. It is not just a training. It's a certification we are giving you. It's an embossment. The commission is putting our tag on you and telling the entirety of the world that this person is qualified enough to run, to advise, to run, to provide data protection as a service. And for all that, the training is costing this much. In fact, we do understand that the systems are hard and the nation is tough.
Yeah, but over time.
But yes. But if we consider the value attached to the amount, let us be fair to ourselves.
Okay.
It's a helpful day.
So let's go on. You talked about the fact that companies must put in adequate security safeguards. You know the risk in terms of you can have an SSL, you can have all the infrastructure, but sometimes it's quite difficult to, there can be security breach. So from your point of view, what do you consider as adequate security measure? Because I know that you can buy a proper Microsoft, you can buy an SSL for your website, you can buy, but yet they're not free from any attack. So from your point, what do you consider? And also in answering that question, let's be guided by the fact that there are different levels of entities in this country.
All right, thank you very much. So the adequacy of data security safe measures, I want to say that is not only determined by the commission. All right, so the adequacy of the data security safeguards, the determinant of the adequacy of data security safeguards is not only on the commission, it is on the institution. So it is only, so we give the leverage for the institution to determine what is adequate. And it must work. It must be adequate enough, because the commission does, unannounced audits and all that, and we can find out. So what I'm really trying to stress on is the fact that the institution must understand what is adequate for them in protecting the data. The security safeguards, the data they have is the responsibility of the institution. And when the commission comes in to audit it, we must find it adequate as well. So for an institution that does a lot with hard copy papers and all that, the adequacy of the security safeguard systems could be a locker and a lock, and the key is kept well with somebody. It's adequate. And an institution that is digital would have to employ systems. And the systems, if a company like Bank of Ghana, we expect them to put some more comprehensive and complex data security safeguard systems than a company like maybe an SME that is a manufacturing firm or something like that. So we are saying that the adequacy is determined by the institution, and of course, they must put in place every other thing, and then the sensitivity of the data and the volume of the data they control.
Yeah, I appreciate that, but if the law says that you have to put in an adequate measure in place, it will be appropriate that the commission gives some guidance, because from experience, I know that it costs a lot to put in security infrastructure, IT infrastructure to safeguard this personal data. Merely having a lock, and those ones are mundane. But nowadays, as you alluded, it's data. Everything is electronic. You must have an external backup. You must have what is cloud-based infrastructure, what is encrypted, who has access, even on our phones, who has access and all that. And those things come with a cost. So be very appropriate that the commission provide some safeguard, because if you leave it to the discretion of the data controller, then it will become a problematic. And that is why we have a number of third parties sending us unwanted loans, unwanted stuff. So I think it would be appropriate that the commission issues some guidance in that respect. So nowadays you will see that CCTV cameras are very rampant in Accra. If you go to East Legon, you see CCTV everywhere, private CCTVs everywhere. So does the Act cover security of CCTVs in restaurants and churches and homes? Does it cover that?
All right, thank you very much. Now, the GDPR, as well as our Act, has identified people's images and imagery to be part of personal data. Yes, so people's images is now considered part of their personal data. So that if that answers your questions, so it is part of people's personal data.
Thank you very much for that. But I'm thinking that the cameras, for example, being captured, capturing people's images, the one who is processing that data, who has the camera, who owns that infrastructure, should be a data, should have registered with your entity in order to be able to capture, yes, in order to capture images and recordings and all that. Because you go to barbering shops, they have cameras. You go to restaurants, they have cameras. And if they don't have registration from your end, there is no guarantee that it will not be used for the wrongful purpose. So that is why we think they have to snoop in on a number of agencies who are not registering, because everywhere you pass, there are cameras and informations are being leaked to other persons. So let's go on the substantive matter.
Let me quickly react to that. Yes.
Okay.
Yes, the Data Protection Commission takes the same stand as you have said, that entities that take any form of personal data, including video footages, are required to do the needful, and that is to register with the commission and to put in appropriate data protection security safeguards, and and properly protect the personal data of individuals that they pick, in this case the footages. Now, why I'm so interested in this discussion is that, you see, for me, sitting here as part of the regulating team in Data Protection Commission, I'm happy because these things are becoming more clearer, and it's becoming, it's some time back, these things were not discussed in Ghana. And so the awareness and the alertness of the ordinary Ghanaian to the protection of their personal data is increasing. And for us, it's very important. And so I reiterate what you have said, that the Commission's position is that all forms of personal data, all persons who take any form of personal data must do the needful.
An interesting point is you've seen that there's a lot of proliferation of WhatsApp groups, group chats, and all that. You will see that there's a group administrator who controls that information. Would they qualify as data controller, and would you expect that they would do a registration? Because this is at a personal level, they have information about your conversations. I mean, does the law intend that it will be companies, or is just anyone who processes data?
All right, this is a very interesting discovery you've made. I consider it very interesting. Of course, it is good for discussions like that And then, as it crops up, policies will come up around it, and it will be useful. But WhatsApp groups, at best, in the best of practices, WhatsApp groups are, they are created when people give their personal contacts. I've created a WhatsApp group. I've been an administrator, or I'm on WhatsApp groups. And normally, before a person will get onto a WhatsApp group, they would have given their number. I'm not oblivious of the fact that there are some WhatsApp groups that once in a while will just pop up, and somebody has created a WhatsApp group. You see, and for one reason or one purpose or the other. But the major practice, or what happens majorly, is that WhatsApp groups are created with the permission of people who give their contacts. And so if these people give their contacts, you give your contact out personally.
Okay. Doctor, moving away from that, you will notice that in the business construct, WhatsApp group is now used for business purposes, and some businesses will contact you on WhatsApp. And so my provisional view is that, once you are the administrator, you are processing data. So if it's a business and you are using WhatsApp as a form of communication, you still come under the purview of the law, but that is for a different discussion. So let's go on to other questions. I will ask maybe about 3 questions, then I will open up the floor for anyone who would want to ask a question. Your law requires that you do renewal every year, every 2 years. And one of the difficulty aspect of it is what we call your compliance report, your compliance report. And I have personally had to seek advice, because the kind of questions that is expected to be in the or feedback you expect to have in the report is quite cumbersome. So if you want to give us some guidance on the compliance report and why it's necessary to have a compliance report from the data controller, particularly when most of the company owners are not IT inclined, they are not, they don't appreciate it. I have done some, I have gone through some difficulty because one of my clients that I was engaging was so concerned about security issues. So by that experience, I've learned a lot in that process. But not all of us are much concerned about IT related security and all that. So if you want to shed more light on the data compliance report and why it has to be done, and is there any way that data controllers can get support in that respect?
All right, thank you. So yeah, our compliance report is a very famous. Many data controllers seek some clarity to it, and we always provide. Theo, before I go on to this, let me say that the information, the points you raised about the WhatsApp groups, they are very significant, and I think that I have noted it. And okay. The commission will look into it and place a position on it. Now, what is the compliance report? The compliance report is the report that the data controller, i.e. the company, writes to us. We give you the templates, and then you fill out the templates and you send it back to us, and that tells us your journey on your journey on the practices or the appropriate practices you've put in place in the entire privacy or the entire protection of personal data of your clients. I want to take it again. The compliance report is we send you the template, and then when you fill out the template and you bring us, it gives us an understanding of your journey with data privacy in your institution. So when you fill out the compliance report, and why it's so important is that the Data Protection Commission must get some form of feedback. You see, in the data protection, the essence is not just to get a certificate and let the certificates lay down in your home. The essence is that after you take the certificate, we run some trainings for you, and there are trainings we do. And then after you take these trainings, you go and draft and implement a data protection policy in your institution. That is the essence of this entire commission and the act. That every institution will be running some form of privacy policy around their, around the data they keep and they control in the process. How would the commission know what you are doing? How would the commission advise you on what you are doing? How would the commission get involved and assist you where you don't have enough knowledge on what you are doing? How we get that message and how we get that information is through the compliance report that you've sent to us. And I must accept that the compliance report is technical for any person who does not understand data protection.
I think you need to understand IT because security infrastructure and all that is not just the registration, but you really need to understand a lot of IT. Trust me.
Quite sincerely, I gently disagree. I gently disagree because I've had some of the very beautiful and very well-structured, not just the structure of it, but actually well-meaning compliance reports that have come to us that were written by people who did not have any IT background. They understand data protection.
Maybe from what you said, you don't know, because from one I did, I had to engage the IT of the company. We had to go through a lot to do that. So what you see from your end is a deliverable.
Yeah.
But as to the difficulty that the clients they go through to bring that report to you. So I think that the suggestion making, let's simplify the process. Maybe a template or something.
So maybe in order not to, I respect the fact that there is the need for a person to have an IT, some form of IT background, but I strongly disagree. If you, you have held one or two people. I sit in the office that keep on talking to people about data, the compliance report. I've not done it once or twice. I do it, it's my daily job. And I'm telling you that, and this is a very good information and communication for everybody who is listening to us. You can fill the compliance report without being an IT guru. I'm not saying that you don't need any IT knowledge. And my point is that the compliance report tells us how far the privacy journey of the institution. And privacy is not only about IT alone. Privacy starts from the security man up until the IT and the boss. And so it's a misconception, respectfully, to think that the compliance report can only be filled by people who understand IT. And there is a solution to filling the compliance report and doing it easily and well. Many people must understand that how you get knowledge to fill out, in fact, how to even get knowledge to write data privacy policies for institutions is not just because you understand IT. It happens when you have taken you have been trained. And so here in the Data Protection Commission, we request and recommend that institutions send somebody. Look, let me take this platform to say that the essence of registering with the Data Protection Commission is not to get a certificate. The essence is that you'll be able to lay down policies and principles in your institution that protect safeguards for data that you hold. And how would you be able to do that if you've not trained somebody who understands this whole issue about data protection? And so how can people fill out their compliance reports easily and well enough? Go for the training. How can I be a person who has no training in law or understand anything about law and be able to write a legal structure or a legal framework for a company? It doesn't work. It's not possible. And so the solution to this challenge with the compliance report is in two folds. The commission requests that every institution that is a large scale or a medium scale controller registers and trains a certified data protection supervisor. You tell your friends to do that. It is for their own benefit. It is for their own benefit.
Yeah, we understand that, but not many people would have the resources to come and get a training for their data processor, data controller.
Exactly. And we understand that, and we've made provision for that as well.
Yeah, I know Hilda was very supportive when I was trying to do that, but my point is that
the provision is not only Hilda. The provision is that The Data Protection Commission is creating an avenue, or has created an avenue, for institutions that cannot train a data protection supervisor now to employ a person who has trained to write or to help them in their, to offer data protection as a service. And this is one of the reasons why when somebody comes to train, it's a job market for them, because some small companies who cannot train a data protection supervisor for themselves, if it's a report, if it's about writing, and IGS is here, and there are other institutions here, Grapevine and all this, they offer data protection as a service. If you contact the Data Protection Commission, you want somebody to understand your system and write a policy for you and fill out the compliance report, we'll help you with one. I want to really clear this issue in the air. There are ways that the Data Protection Commission has made for this to be easy. One is that the essence of registering with the commission is not just getting a certificate and hanging it on your wall or using it for the next approval level. No, it is that you'll be able to put systems in place to protect the personal data you've collected. How is that possible? It is not possible until somebody has been trained to understand everything with data protection. How is that possible? Unless the person trains. Now, in an institution that they cannot train, which I understand, the Data Protection Commission has opened the door for you to contact us, and we will help you to get people who will offer data protection as a service for you. I think this is fair.
All right, thank you. Thank you very much. I think it's quite arguable. And I think the regulator ought to make some of these things quite easy. And it's not just going to someone who provides the service, but the service provider is also going to charge you. And we're in a very hard time, When Hilda was chasing me up for me to register, I didn't want to register, even though I had sent a number of people to the place. And I'm sure many people will be dragging, what is in it for me that I'm going to pay data protection some money? So the system has been simplified, and that's why both regulators are doing to ensure that the business community is compliant with the law. The compliance cost should not be that much. But the compliance cost is much, it makes a disincentive for people to register. So that's arguable, like I'm saying. So my final question relates to what are the penalty regimes for non-compliant data protection. So the first one is the non-registration with your agency, and when there's a breach of the privacy of a data subject, what are the penalty regimes in that respect?
Okay, all right. Thank you very much. So to the other point, let me say that the registration system, the data protection registration system, has a roadmap to follow in the filling of your compliance form. So you can understand that even how to fill it and understanding it has also been provided for any data controller to understand on our system. And that also, I think I must be able to make clear. Now, the Act, the Section 95 of our Act establishes that, I want to read it. It says, where a person commits an offense under this Act in respect of which a penalty is not specified, the person is liable on summary convictions to a fine of not more than 5,000 penalty units or a term of imprisonment of not more than 10 years or both. So that is what the law says. That is one of the penalties. And so this is the, I mean, personally, I call this the grievous, this is the biggest penalty a person can get, because I mean, this is where there are no specifications on you've committed an offense, data privacy offense that is not captured. But there are other penalties that the commission, I mean, the Act stipulates. You can find such penalties in the Section 88. I could read a few of them for you. 88 says that a person shall not purchase the personal data or the information contained in the personal data of another person, knowingly obtain or knowingly or recklessly disclose the personal data or the information contained in the personal data of another person, or disclose or cause to be disclosed to another person in the information contained in the personal data. A person who contravenes subsection 1 commits an offense and is liable on summary conviction of a fine of not more than 250 penalties units, or to a term of imprisonment of not more than 2 years, or of both. Now, Section 89 also says that.
Look, I think I've got the most of it. So in effect, if you don't register, you pay 3,000 Ghana cedi, or you can be convicted, or you can still be fined and still be in prison for not complying. So that's a good one. I hope businesses will take it very seriously. So the floor is open for any questions from anyone. Any questions, you are free to ask the question. You raise your hands and we will call you. I suggest a dead person does not have a data right, correct? The dead person, do they have a data right? The dead is gone. And a question for Emmanuel, what are the approaches for businesses to ensure that data protection regulation compliance on their websites?
It is still not very clear. So data protection compliance on people's websites?
Yeah, particularly on websites, yes. Approaches for businesses to ensure data compliant website protection regulation on the website. You know, in the UK, they have GDR, as we talked about in the past. I think, I think that's where he's coming from.
Okay. All right. Okay. Thank you very much. I mean, let me say that we expect that it's in two folds. The first fold is that when this morning, I may be able to bring this in and to help. This morning, I had a business owner who was here and informed me he was asking the permission to put their certificate online, and based on that, assure their clients that they are compliant, or they are in the good books of data protection. I said it's very advisable. So one is that we expect that institutions that are in good standing and are doing the right thing actually take steps to inform the public, of their compliance journey. Many good institutions clearly state their privacy policy, on their website. They clearly state it. And what I'm saying is that it's in two folds. It is both helpful for the institution because it helps any concerned citizen to respect the integrity of the institution. And it's also helpful for the commission because it helps us to, maybe as we grow, as the system matures in this country, it will help us to simply weave out those institutions that are not in good standing. So maybe through this platform, I would say that we expect, or we encourage institutions that are doing the right thing to put their compliance journeys on their website, on their systems. Of course, it's also allowed for them to put their certificates on their website and all that to assure their client and the public of the protection of their data. I'm not sure if I handled the question.
I think it's all right. So it's okay. Any other question from the public? Any other question? Madam, is it Sylvia? Sylvia.
Yes. A very good afternoon to you all, and I must commend you for the effort in raising awareness of the Data Protection Act. I am the CEO of IGS, as we mentioned. I thought I would make some contributions to add to what has been said so far. And a couple of things I wanted to clarify, and Patrick did it brilliantly, is that registration does not mean you're compliant. It's just a beginning of your journey. We in IGS, we do a lot of awareness and training like this, but I'm not here to advertise our services. But I want to encourage all here to follow up from this webinar and find out what they need to do. Compliance is a journey. You raised a very good point when you talked about the compliance report, and did say you need IT knowledge. The report, actually, I have helped a lot of organizations complete their compliance report, and it simply is a picture of a state of your current compliance. And when you're presenting that report, you look at different areas. You look at, for example, you asked the question now about how should people be sure of making sure they are compliant on the website. One way of doing that is, if you look at section 27 is making the data subject aware through a privacy policy. That is also covered in the GDPR, which you mentioned, under section 12 and 13. So I think what I wanted to add is all organizations here, please take this very seriously. It is as important as any part of your compliance journey in your industry. So data protection is not just an added or a burden for you to take some boxes. It is really a journey, and to show your customers, your clients, your employees that you're actually taking data protection serious would depend on your processes and your procedure you put in place, both internally and externally. So for me, I just wanted to add and encourage everybody to take this seriously. It is only a matter of time that your customers, your clients, your employees, your church members, data subjects will begin to demand their rights. And when they demand their rights, they are not asking only what security measure you have. They want to know why you are sending them information, where you got it from. That can be explained on your privacy notice on your website. So on a website, a notice confirms or tells the individual who is using your service that you take data protection seriously. So even in Europe, my background is also a GDPR expert, and I do a lot of work in Europe. Even the GDPR has not endorsed one single trust mark to say that a company is compliant. It is your deeds, your actions, the processes you put in place. So to make it transparent, Dr. Patrick talked about openness. Another word is transparent, is to exhibit your accountability, demonstrate it. So for me, I think this is a very good webinar you have held. We also hold our own webinars, and I'm sure when the time comes, people who want to join will have access to it. But I'm really happy that this is happening. And kudos to both parties.
All right, thank you, Sylvia. We will bring you a bill from the UK Chamber of Commerce for advertising. If you're not a member, you have to register ASAP, because other than that, we'll come after you today. Any further question? Any other further question? Madam Frances, do you want to make a last comment before we want to wrap up? Madam Frances, is there something you want to say?
Oh, no, I was saying that I have a question from Business 24 newspaper. They want to know how valuable or profitable data is to the tech economy. And during the Commission's years of existence, what has been the achievements and challenges so far and the way forward?
All right. Doc?
Thank you very much. Theophilus, I think this could be a whole webinar, and it's and it's the value of data is invaluable, especially in the times we live now and the times to come. I think I spent a good time to explain the value of data at the beginning of my presentation. The value of data is the value of this generation and the times to come. Data is the new gold. Data is the new diamond. Data is the new air. The progress of every institution, the advancement, the power, the wealth, the importance of every institution is dependent on how much personal data, how much information they have, concerning their area of business. So as for the value, it is absolutely invaluable, especially now. It's huge. It's so huge that we may not be able to value it. That's what I will say for now. Now, all right. What has been the Commission's, for those 5-6 years that we've been operating? What has been the Commission's successes and the entire journey? I will say that the Commission, we have moved a lot. We have moved a lot, and this webinar tells, to have brought us here to discuss. The Commission is aggressively bringing the populace, Ghana, to a place of understanding the value of personal data. We are pushing data controllers to do the needful and to register and to comply and to administer data subjects' rights to them. And at the same time, we are pushing data subjects to know their right and to demand it. And we are bringing all these in a very, we are synchronizing these two sides together to form a very healthy ecosystem for data protection. Again, I explained and I mentioned earlier on that the Commission has taken a very, very aggressive drive to bring in other regulators on board so that data protection certificate and data protection will be an eligibility criteria for all other institutions. And we see that strategically, that is how we'll be able to touch base with all institutions that are needed without us necessarily having to chase after them. And all the other strategies that I'd spoken about earlier, like the enforcement journeys that we're embarking on, publishing in the media, advising the public on who to deal with, especially in tandem with data protection and the prosecution agenda that we have taken. The challenges is quite clear. The challenge is that unfortunately many Ghanaian businesses and companies, I'm sorry to say this, but that is my personal experience, that people are very slow to change, and people only react quickly to change when it becomes injurious, and that in itself is a challenge. So we know, like Sylvia said, it is only a matter of time. It is sincerely only a matter of time that all data controllers will know that the earlier they had participated in doing the right thing with data protection, the better for them. So we are on the move. The commission is ever growing, and the strides, the impacts are ever increasing, and we are confident that we'll keep moving up and progressively.
Dr. Donald, thank you very much. We are grateful for your time, for the insightful presentation, and telling us a lot of very useful information for businesses who are members of the chamber and other people who are not members of the chamber. So key point to leave everyone with is that every company is expected to have a data protection policy to safeguard the personal information of their subjects, so which might normally be employees or customers or any other persons that they keep their data. Every company is also expected to register with the data protection, and there are different tiers of registration for businesses. The least is 120, if my understanding is correct, and the mid is 900 and something, and the 900 and the higher tiers, I think 1,000, circa 1,200 or so.
1,800.
1,800, yeah. So you're supposed to have that. You are supposed to put in adequate safeguard measures to protect these data. So you need to invest in infrastructure, and what you invest depends on your level of operation. Application can be done online, and if you need support, the Data Protection Commission is available to support you. You're expected to renew your certificate every 2 years, and it comes with a cost. If you need help with that, you can seek help with the commission or any of the authorized agencies, right? Which are in line with yes. So one of the key things is data compliance report, and if you need help, the commission can support you, or you can consult a law firm, and law firms can also support you because it's all part of the legal. So companies must
registered law firms who have trained data protection supervisors.
So my colleague has is registered. So some law firms have also registered. So it's not just about registering, but law firms can also advise you on your data protection compliance, yes, which cannot be taken away from by the Data Commission agency. So we are very grateful, Doctor, and everyone. Grateful to the team, Ajoba, Sarah Hadley, Jocelyn, for all the support, and the directors of the UK Chamber of Commerce and the High Commissioner. We wish you a nice weekend, and we will come again with the next series in the nick of time. Have a nice weekend and take care, everyone.